SJC-12613, James Dickey v. City of Boston Inspectional Services.
Mr. Dickey, good afternoon. You've got 10 minutes.
Hi, thank you, actually. This case initially started in the Boston Housing Court. I had asked the Housing Court to remove Stuart Schreier as a receiver for a piece of property that is owned by an LLC I am the single manager on. What occurred is the Housing Court judge initially said that I didn't have standing to actually ask that he be removed. I had actually known of a prior situation where Mr. Schreier was involved in a transaction where someone was tricked into selling a client of his a house for $1. It was a house that was going to be put into receivership that the Housing Court was contemplating. What they did is they transferred the house to Jonathan Kay, who was Mr. Schreier's client. He was going to fix the house up and sell it back to him at his receiver's fees plus costs. What occurred is at the end of the fix-up, he actually told him he wanted the house, he would only sell the house to him at market. But anyways, and Mr. Schreier actually was the individual that drew up the deed that actually sold the house back to these people who did pay market. Okay, that was in the Housing Court. The Housing Court since said I don't have standing because I am the manager of the LLC. I disagree with that because I have a guaranteed mortgage that's on the property, number one. And number two, the petition does not indicate whether or not I'm being sued, which I'm named on, whether or not I'm being sued in the individual capacity or as manager of the LLC. This case has since been somewhat changed in that I am now asking this court to basically set up a department similar to the Board of Bar Overseers for the receivers. And I've submitted numerous questionable activities that the receivers have done over the years.
Are you opposed to any receiver or just particular receivers?
Excuse me?
Are you opposed to just having a receiver at all?
What I'm opposed to, and I'm not actually opposed to the statute as it stands, I'm opposed to the interpretation of the statute by the receivers in the Boston Housing Court. What occurred in 1980 in Perez versus Boston Housing Authority, this court decided that the receivership statute, it's Massachusetts General Law 111, Chapter 111, Section 127I, that this court, that the Housing Court and other courts could impose a general receivership where the receiver steps into the shoes of the owner, and that could entail the sale of the property. In 1993, the statute was amended to indicate that the rights, duties, and powers shall be specified by the court in accordance with the provisions of this section. When you look at the receivership statute as it stands now, it does not allow the receiver to sell the receivership property. What's been occurring is because the amended statute allows the receiver a lien on a piece of property, the building is basically unsaleable during the receivership. A bank will not finance the property. Because of that, they've been able to do both execute deeds and have foreclosure sales within the receivership case, and no one will show up because no one can finance the property. They then purchase the house, the building themselves, get the receivership dismissed, turn around and sell the property for a huge profit. I've also submitted to this court numerous deeds where that has occurred. In addition, I know of, since I've filed my brief, there is the BBO is looking at the transactions of an attorney. It's Attorney McAuliffe. For 3 receiverships, he was able to, within the receiver, purchase the property, and then shortly after the dismissal of the receivership, sell those properties for a gross profit of almost $700,000. He clearly put $500,000 in his pocket on 3 receiverships. And the BBO's they're still reviewing that situation. But,
And with regard to your guarantee, nobody right now is seeking to have you pay on that guarantee, correct?
that is correct. But what it is the mortgage on the property is only a few thousand, but there is a case in the land court that would actually change that. I'm actually, on the mortgage, there was 4 properties. I'm trying to void a foreclosure. If I'm successful in that, the amount on the mortgage will be in excess of the value of this house. And what could occur is if you do not let an owner, a single owner of an LLC, normally most mortgages do ask for a personal guarantee. And what could happen is that the property could be lost during the receivership, then the mortgage, the person that holds the mortgage could then go after the property owner's own house. So I clearly have standing in the housing court because of that,
Housing court on behalf of the LLC or housing on behalf of yourself?
myself.
Are you a party
Um,
in this matter? Because you're not the owner of the,
Yes, when I read the petition, I believe I was a party, and the judge was initially allowing me to file in the case, the housing court case. But what it is the case that's in front of you right now. It's since changed in that it's turned into a petition asking that this court actually set up a separate department similar to the Board of Bar Overseers, in that the receivers have to answer to someone else than just the judge. It'd be quite simple to do. All you have to do is expand the BBO's jurisdiction. The other thing I'm questioning is as to whether the receivership statute applies to unoccupied property. I mean, when you have a house lot, whereabouts from having a house lot to actually having a tenant move into a complete unit, does the receivership statute actually kick in? I say it does when the tenant moves into the property. Anything prior to that, it's just doesn't make sense. Someone could put up a foundation on a piece of property and then all of a sudden seize the property because that foundation does not apply, does not conform with the sanitation code. That just does not make sense. Anyways, and that's about it.
okay, if there are no further questions, thank you.
Sure.
Does anybody have any, I understand that the city of Boston did not file a brief, so they are not entitled to argument. Are there any questions of the attorneys for the city? And hearing none, we thank you for,
Good afternoon, if it please the court. My name is Robert Arcangeli. I'm representing the City of Boston Inspectional Services Department. If I may also point out, I'm joined at table by the receiver in this action, Mr. Stuart Schreier, in case the court might have any questions for him as well.
okay. And hearing none, we thank you both for coming here.
Thank you.